I want to welcome everybody to our webinar today, What Health Professionals Need to Know, a deep dive on regulatory questions in prescribing and dispensing mifepristone and misoprostol. And we're going to talk today about some of the issues around interstate practice of medicine, compliance, and standard of care questions. I'm Harry Nelson. I'm the founder of Nelson Hardiman. I'm really delighted to welcome everybody today. I want to thank everybody for joining us. And I want to give a special thanks to Dr. Elizabeth Raymond, who co-presented with me on the first webinar in our series in June, and has been really a tremendous source of information and education for me in understanding the clinical dimensions of the issues around medication abortion and telemedical use of medication abortion. I want to say that we are in territory where, in many respects, health professionals, clinicians, pharmacists need to become, at least on an amateur basis, understand lawyers or people who understand complex legal and regulatory questions that we'll talk about today. And for me, this has likewise been an area where, as a lawyer, and I think for all lawyers who work in this area, it becomes necessary to address the clinical issues. And I want to apologize in advance if I say anything on this webinar that is clinically questionable, but I will do my best and appreciate your patience. So just a disclaimer, the webinar is intended to be educational in nature. It's not intended to be relied upon as legal or in any way clinical or medical advice. I'm expressing my personal opinions and not the opinions of Nelson Hardiman or any other organization. And I would encourage any person, any individual who's considering what to do with this information to consult an attorney directly. I want to say, by the way, in advance that we will provide, upon request, we're happy to share the slides from today. We will make a recording available as we did on the last webinar. If people have questions, I'll try to answer them before the end of the webinar, but we'll also provide written answers if we think they would be useful for other people to hear. And I want to say just a quick word before we get started, just to share like kind of my background and perspective on these issues. You know, personally, I've been practicing for close to 3 decades. I started my career on the institutional side as a healthcare regulatory lawyer. I came to California about 20 years ago and started advising clinicians, heavily physicians, having trouble with state medical boards and other clinicians with licensing board issues and trouble with government agencies, peer review bodies, really trying to help people who had after they had made mistakes. I pivoted and I used that throughout my career to try to give regulatory guidance and strategy on how to do things correctly in a whole bunch of emerging areas with a really heavy emphasis on telemedicine and other kind of innovative practice models, and think a lot in the course of our work about the risk issues in that context and lines of practice of medicine. And I share that context because I hope that there will be value for everybody listening today. But it's only, what I want to emphasize is this is one perspective. And one of the things I've tried to do in the presentation today is to highlight where some of these questions fit into, and some of the advice we give does fit traditional models, and some ways in which we are in really new territory. And how do we deal with those challenges? So just before we get started, a quick word. As I mentioned, we have the previous webinar, which for people who missed that, upon request, we're happy to share the link to the recording. We have 2 other webinars scheduled in August and September. One is going to address liability risks specifically, and we'll talk a little bit about that today. And then in September, we are intending to comment on some of the privacy issues, which also will be touched on today. So in terms of what we would like to cover today, I want to start with the topic of abortion exceptionalism and how it is in tension with telemedicine regulatory issues, and some of the practical ways that I hope clinicians and others will benefit from thinking about that and perhaps from challenging that. I also want to comment on the additional and unique challenges of the threats coming from anti-abortion activists and political leaders, and how they relate to how those affect professionals and patients in this context as it relates to telemedical use of abortion. And I want to get to a very specific map. I'm going to show a number of maps today relating to where medication abortion by telemedicine is available, where it's not telemedically available and why, issues like how much providers need to do to verify locations. I hope those will be very specifically useful. And then the final part of the webinar is going to be looking at the encounter with patients and thinking through what providers need to be paying attention to. So let's get started. I want to talk first about this topic of abortion exceptionalism and how it is in tension with the telemedical regulatory framework. So in an ordinary telemedicine framework, the dimensions which need to be thought through in the encounter are first, what is necessary to establish a clinician-patient relationship? Second, what does the clinician need to do to evaluate and treat the patient? Third, what kind of informed consent issues need to be addressed? Fourth, what kind of medical record documentation needs to be maintained? Fifth, any issues that come up around prescribing and what needs to be done to prescribe in compliance with the law and in an appropriate way. Sixth, or I may have got my numbers off, continuity of care issues, any kind of follow-up instructions that need to be given. And of course, there's the issue of dispensation, which can be done in some context by the clinician, by a physician or nurse practitioner or physician assistant, or by a clinician writing a prescription, issuing a prescription, classically dispensed by a pharmacy, which is the ordinary method in our system. So I've included under each of these topics a number of the ordinary questions that come up. And these are all questions that are relevant and we'll talk about within this webinar within the telemedicine context. And I'll come to these questions in specific in the later part of the webinar, right? These are the questions that are universal, whether you are prescribing a blood pressure medication or whether you are prescribing mifepristone, but they are incomplete as a description of what needs to be covered to prescribe medication abortion. I want to just take a moment, and I apologize for as a lawyer just commenting on clinical issues. But one of the takeaways for me from the work of Dr. Elizabeth Raymond and from her comments on our previous webinar is that medication abortion appears to fit very well within an asynchronous telemedical model. And by that, I'm saying it appears that everything about the clinical research indicates that medication abortion can safely be provided in a synchronous telemedicine model. That is when the provider and the patient are on a live encounter together across a video interface with audio, or alternatively in an asynchronous model when their data is going back and forth between them, which, by the way, is a model that we have seen has been extremely popular and appropriate for issues that are where there is an element of privacy, a priority on privacy, and a lot of challenging emotional dimensions to seeking the medication. And that's not exclusive to medication abortion. That is a real benefit of an asynchronous model I just want to highlight. But one of the takeaways for me from the last webinar is that the data, the clinical research, and I've included an example of one of the studies that I'm referring to that Dr. Raymond and others have put together, have indicate that patients who are pregnant and want to terminate a pregnancy can reliably self-identify the contraindications, meaning they can answer questions and identify when they have risk issues that would be a problem. They can reliably describe the duration of their pregnancy, the location of their pregnancy. The research has shown that RH testing is not needed in very early pregnancy, that ectopic pregnancy is addressable later, and that the overwhelming majority, 95% of patients, will need nothing other than the direct regimen. A small number will need additional pills or an aspiration procedure, and that 99.5% of the time, there's no further need for intervention. There's no risk of hospitalization. We are talking about an overwhelmingly medically safe procedure, which is why I'm referring to this particular study, which approved clinically of both asynchronous and synchronous models. And I'm simply relaying this because I think it is important context to understand the exceptionalism that I want to talk about. So what do I mean by abortion exceptionalism? When you look at the laws, and these are not merely the laws in states that are hostile to abortion. These are laws in states that are permissive of abortion also in many cases, and I'll go through the list later in this webinar. We find lots of very specific exceptional laws. So obviously there's the category of the outright statewide abortion bans, the fetal heartbeat laws, the gestational limits on abortion up to a certain point in the pregnancy. But those are not what I'm talking about as the relevant pieces that I think people should be focusing on within this webinar. What's interesting when you look around the country is that you see many limits on the abortion procedure, including medication abortion, which because these laws don't distinguish in any way between abortion as a procedure in a health facility and when done by medication. And you see requirements that the clinician be in person to examine the patient. That doesn't appear on other. We don't require that for the vast majority of other conditions and medicines. We require in some states in-person counseling requirements, which are separate from the clinical examination. In some states, in-person requirements that the patient ingest the medicine in person, that it be dispensed in person and not mailed. Waiting periods where it can't be given right away, where the medication can't be given right away. Ultrasound requirements, which I'll show you. We'll go through those on the map. And prohibitions on non-physician practitioners, advanced practice nurses, nurse practitioners, physician assistants prescribing. So those are very specific exceptionalist elements of state law that we're going to talk about. And then we have telemedicine specific prohibitions, states that have permissive laws for providing telemedicine, but specifically say that they exclude any permission for telemedicine to be used, or that don't allow for asynchronous telemedicine. And I want to call people's attention, and I'm going to talk at length in this webinar about the REMS requirements, risk evaluation and mitigation strategies that the FDA has enacted. These include a requirement that providers be certified to use this medication by the manufacturers, that the patients sign a very specific agreement, that physicians, clinicians dispense medication guides. These are unusual requirements that are all exceptional to abortion and should be. And I hope one effect of this webinar will be to have people call into question the appropriateness and what can be done to remove these in jurisdictions that are not intending that or may not be fully conscious of how many barriers have been set up to telemedicine use of medication abortion. Okay. I wanted to talk about the additional and unique challenge that the anti-abortion threats to providers and patients are creating, and to offer some thoughts on that. In order, just to go back to the concept of what is sort of ordinary telehealth in other contexts, require. I've had the privilege of working on a number of emerging uses of telemedicine, including a lot of focused use of telemedicine for particular conditions. And the questions that generally come up are, can we reliably validate the standard of care and meet those requirements either through an asynchronous or synchronous telemedicine, encounter? And usually the issue with asynchronous is, are there diagnostics that we need? Do we need a lab? Do we need labs? All right. Does the patient need to have imaging? All right. Those are the kind of questions that come up. And can we provide exclusion criteria that the patient can use to self-identify and determine if a particular telemedicine service is appropriate, right? Can patients screen for, and can physicians use patient responses to screen for risk and suitability of treatment and carry out the appropriate examination and render a diagnosis and treatment plan as appropriate, right? We always ask the question, does this particular state impose limits on telemedicine? A certain number of states, Delaware, for example, still do not, as of this date, allow for asynchronous telemedicine. They only permit synchronous telemedicine in Delaware. And then we look at state medical boards and their focus on enforcement issues. And here, this is where I want to say, I think this is what's really unusual about this issue, is that I have found that there is important work for providers of, emerging telemedicine therapies to educate state medical boards. But state medical boards have their hands full dealing with real threats to patients patient harm, and to issues like clinician impairment, right? Clinician boundary issues, clinician fraud. State medical boards are not predominantly concerned with sort of blocking new therapies. And frankly, my belief is that state medical boards are not going to be the thrust of the threat here to providers, and that applies to state pharmacy boards and to all clinical licensing boards. Ordinarily, the risks of criminal enforcement for licensed professionals, and also, by the way, for the unlicensed people who or entities that provide the technology platforms, right, which are in a common telemedical model. If you look, for example, just to take Teladoc as the largest public telemedicine company, what we see is that there is the public entity is actually what we call a management service organization, an MSO. It's a technology platform that's providing administrative services and owns the brand Teladoc. But the services are provided through licensed professionals practicing in professional entities, professional corporations. So ordinarily, the risk is state licensing board risk, because licensed professionals are ordinarily only facing criminal risk if they are practicing medicine without a license. That would be an example of a provider licensed in California who decided to practice medicine in a different state, or aiding and abetting unlicensed practice. But these are very narrow and very unusual. We have examples of them, but they tend to involve very extreme circumstances. And so instead, and what we're seeing in the case of abortion, and very, very different kind of threat, right? So we have the example from the Texas Freedom Caucus, and this was a letter sent that many people have seen. It received national attention from a number of congressmen who are part of this Freedom Caucus, who sent a letter to a law firm, basically to threaten the law firm as being complicit in the murder of unborn children and in illegal abortions. And by the way, not only referring to the period before the Supreme Court ruling in Dobbs, and simply for its health plan coverage policies of permitting patients to travel. So this is not a typical threat that we've ever seen before in a telemedicine context. And just to take a look at what some of the threats that are being made in this letter include threats to that basically anybody who participates in any way in kind of assisting or enabling a person to seek an abortion, even to travel out of state, which the Justice Kavanaugh, concurrence in the Dobbs decision says is a completely protected right. And Justice Kavanaugh was basing his comment in very well-established law that there's a constitutional right to travel, to interstate travel. In the state of Texas, the Freedom Caucus is making it known that they don't agree, and they regard that as a potentially criminal act in Texas. Likewise, this idea that a patient who ingests any part of the mifepristone, misoprostol, I'm going to refer to Miffy and miso for the rest of the webinar, that somehow, if any part of it is, even if it's appropriately prescribed and dispensed in a different state, the suggestion that if any part of it was taken in Texas, that somehow would be a criminal prohibition. This is an aggressive position in the law that we have not seen in any previous telemedicine context. And I would describe it as an attempt to weaponize the current law, really to try and intimidate and use a very broad definition of aiding and abetting. The way that I think about this as a lawyer is that, you are always facing as a lawyer the question of what the law or regulation actually says, how it is reasonably interpreted. It's very important always to understand how government agencies and regulators understand it and their guidance, which is, even if it's not law, it gives you a clue to enforcement, like how you can expect it to be enforced, how courts interpret it. But what we're seeing in this case, I would argue, is an example of how activists on the other side are really trying to intimidate those who would otherwise lawfully exercise their rights in this context to travel and seek a medication that is lawfully prescribed and dispensed in another state. And the challenge of the American system, I get asked to comment on risk issues, and I wanted to just add this thought. is that, the problem is that we are sort of at risk of what other people sue for, right? So, if a organization is willing to pursue a lawsuit as the Texas Freedom Caucus was explicitly threatening, they can force individuals, organizations to spend money, and even beyond the money, to incur a significant amount of stress and time. And this is a really quite a serious risk. And I want to just offer this thought before we dive into the real substance of my thoughts today about how this is playing out. And I pulled a number of headlines just from the last week alone, where we are seeing the way that the law is being weaponized far beyond just saying you can do telemedically, you can do medication abortion in this state, but not in that state. We are seeing this expansion into other treatment having nothing to do with medication abortion, access to miscarriage treatment, access to other prescribing. We're seeing a very severe situation in Montana, where clinics in Montana are preemptively saying, we will not treat out-of-state patients. We won't give them access to medication abortion, even though it's very clear that they have the right to do so. That is a response to intimidation, and I'm not faulting anybody for that response. I'm just calling it out, and I wanted to make the following kind of statement about it. I think that this is essentially a form of success because what is happening is patient trust in what they can communicate to providers is being undermined with respect to abortion. Providers are being pressured to avoid any activity that touches abortion hostile states. Providers in abortion hostile states are clearly being pressured to stay away even from things that aren't abortion, right? From the morning after pills, from the Plan B, from the from miscarriage treatment, and what's happening is that this is going to drive some patients to travel to abortion permissive states, where hopefully providers will have the confidence to know that they can lawfully treat people who travel. There will be some issues of patients attempting to utilize telemedicine platforms by representing themselves to be elsewhere, and I want to talk about that issue, and to have medications mailed indirectly. And then we're going to see the biggest, likely consequence is a move away from medication abortion to self-managed abortion from international sources, including aid access in particular. And so, and what we've seen, and I included here underground trafficking only because that is the evidence out of places like Brazil, which have been already living with these kind of a legal system. So I wanted to frame it here just to add my thought to it. I really think there's a dual education and awareness challenge, right? We are talking, the rest of this webinar will largely be devoted to telemedicine where it is legal. But the question is, how do you create education and awareness of self-management resources everywhere else? And one of the questions that comes up frequently in our practice is, what can we do that is not the practice of medicine? First of all, that question comes up when unlicensed people want to provide a service. By the way, this is how life coaching went digital, right? Anyone who wanted to be a life coach had to be very cognizant of where were the lines from the licensed practice of a mental health profession. What can non-clinicians do? And what can clinicians do that is not going to be the practice of medicine? There is more to say on this topic, but I do want to point out there's a number of federal appellate cases recognizing physician First Amendment rights that come out of the cannabis context, the right of physicians to make recommendations, even where they cannot lawfully prescribe, the right to educate, the right to inform. And I would like to suggest to people who might be interested in listening or want to share this idea that I think it's very important to create good options for coaching and for things that are not the practice of medicine. And I see that that's already happening, obviously, but I think there's more that can be done there. All right, I want to turn my attention to the promised deeper dive on regulatory issues. So where can you do telemedication abortion? There are 20 states today with to arrive at where you can do telemedicine abortion. And I'm not commenting on this slide on synchronous versus asynchronous. You have to obviously eliminate all states that have an access limit on telemedical abortion. I'll talk about gestational limits on the next slide. You have to But just to cut to the chase there, any state that all the states that have gestational limits also have into other barriers to telemedicine use of medication abortion. You have to eliminate all the states that require the physician's clinical presence or the states that require in-person counseling. You have to eliminate the states that require ultrasound, right, as a condition, because obviously that can't be done in a telemedical context. We have to eliminate the states that have waiting periods and states that permit dispensing of mifepristone and misoprostol by mail. So you end up with this list of states. These are the state, and by the way, this list is evolving and changing. I have enormous respect for a number of other websites that are out there, Kaiser Family Foundation and others, who have listed Montana and Alaska as states where it was possible to do telemedicine. And frankly, it's very difficult to get to the bottom line. It's fluctuating and evolving. You have competing statements, and often you have to go, where state medical boards will provide clarification. That can be a valuable resource, but we often see that's just not something that some state medical boards in many states are going to comment on. They don't consider it to be their job to proactively give advice in areas like that. And so these are the states where telemedicine is still an option, either in a synchronous or asynchronous form, depending on the state. Now, I wanted to point out, when we talk about abortion exceptionalism, there are a number of states which have limitations on telemedicine that remain states that are allowing for in-person abortion. Some of these states are states that have efforts underway to create greater limits. And so some of these are states where there are limits that are currently being challenged. I mentioned Montana, where Planned Parenthood of Montana is currently challenging the in-person requirement and the mail ban on mifepristone. When you look at those exceptionalist issues, you see I included Iowa, for example, as a state that includes both an in-person and ultrasound requirement. A number of states, particularly Michigan, it was a little bit maybe surprising to people. It has an in-person provider visit and an ultrasound requirement and a waiting period, right? So we're seeing some of these states are in flux, but these are states where, as of today's date, it is possible to have a medication abortion, but not in a telemedical context. As I included on the states that are in the green striping, Arizona, Nebraska, Kansas, Kentucky, North Carolina, and South Carolina, those are states that went further and require more than 1, 2, or more in-person provider visits and a prescribing clinician present. So it almost has been like an arms race of states trying to put exceptional additional requirements on abortion, on medication abortion. And again, even though the clinical studies are showing these requirements to be unnecessary, particularly in early use in the pregnancy of medication abortion. Okay, so states where abortion bans limit the question, there are only 17 states there are 20 states on my math isn't good. Sorry, there are 17 states on this list. We are on our way towards 20 states, roughly 20 states, having abortion bans. It's very tricky, literally week by week map, and I am not the person who's tracking this as well as some of the advocacy organizations that are doing the frontline work. But we have states, for example, like Utah, Arizona, and Kentucky, where there is a ban, and it's only a matter of how the legal proceedings on the challenges to those go forward that create a situation where there is some room for medication abortion use. We see that I have included 4 additional states: Idaho, Wyoming, North Dakota, and Tennessee, that as of today's date have not yet enacted bans, but are in the process of doing so. We have Kansas, which has a ban coming up, and this list is going to. I've heard the number I keep hearing is about 20 states will eventually end up with some kind of abortion ban. Several of those states are on this list, which is the gestational limit states, right? And here we have a number of states that enacted gestational limits that are in the process now of trying to move to a complete ban, and so we see, and also different limits. As I mentioned earlier, all of these states that have gestational limits have independent reasons why, to the extent that you can still do pre-gestation abortion, you do telemedicine abortion, most commonly because of sound requirement, but also because of in-person clinical where there's room to do telemedication, to use telemedicine for medication abortion. Okay, I wanted to take a minute to talk about a very important and evolving issue, which is what is the responsibility to verify patient identity and to authenticate patient location. This issue has been coming up widely. Providers in states that are permissive have been asking questions, and it's not an easy question to answer. But what I've done on this slide is I've tried to identify those states that have some requirement either for requiring verification of patient identity, and then to distinguish between those states that require a verification, meaning which could include a patient-provided answer to where the patient is located, or an authentication, which would suggest some kind of double checking or validating the data provided by the patient, and merely relying on the patient for the patient's information about where the patient is located. So what we see is that on this list, the states that are not colored, that are light gray, and the lightest color on the slide, are states that have not enacted any requirement to in their law or and these are typically in the telemedicine regulations, to inquire about the patient's identity or location. Since roughly 2014, we have been seeing a movement for more concerns in the context of telemedicine fraud to identify where the patient is based, because where the patient is living or located will be the state that will be determinative for the application of telemedicine laws. So that I included on the map that are colored dark gray, that would be California, Montana, North Dakota, Louisiana, Mississippi, Vermont, New Hampshire, and Maine. States that have a requirement. California is implicit. The other states are explicit. That you but they don't specifically reference location. And then we have the states in the dark purple that would include North Carolina, say that you need to verify the patient identity, but in many cases, and they use different language in these statutes, but often that is just simply a matter of asking the patient for the patient's address. You know, the patient, obviously there may be an address on the ID, but the patient may have an explanation. And then I wanted to flag that there are 8 states, I believe they get the number right: Utah, Colorado, South Dakota, Oklahoma, Kentucky, Virginia, and Delaware, where the states actually call for authentication of the location. Is there any problem with my cutting off? Should I take? I'm going to switch out the microphone. Excuse me, give me one. Can you hear me? Well, it's on. Yeah, sorry. I'm getting a technical. I'm being told that my microphone was not working. To me, 1 second here. I think people can. Okay, great. Sorry about that little technical issue. Okay, so we have these states I mentioned that have an authentication requirement that suggests some kind of verification of the patient's address, and a number of those, by the way, I think these states, some of these states are obviously not places where telemedicine abortion is even an issue, but some of them are. And I think this is an issue that I think is going to require more attention. But the interesting thing to note is that this is not an issue that has been predominant in telemedicine in the majority of states, right?
But these are the states where there is a specific authentication requirement, and this question of how much a provider can reasonably rely upon a patient is a big one. Our view, expressed on the previous webinar, is that in a state that does not explicitly require authentication, a provider is permitted to rely upon the patient's representation and to assess it, and that there is no requirement for any kind of further examination. Obviously, states that talk about authenticating are clearly looking for some kind of further validation, presumably a technological validation. So, okay, I want to move to, and I'm going to come to, I see there's a number of questions. I'm going to come to those at the end, in the interest of making sure we get through the next piece of the puzzle, which was recommendations for compliance. So I wanted to start off with some comments just about what needs to be done, going back to the abortion exceptionalist issues. As a result of the FDA requirements, one of the fundamental issues is this requirement that a provider be Mifepristone REMS certified, and that is done by completing this provider agreement, which is available on the FDA's website. There's one for the manufacturer Danco, the manufacturer of Mifeprex, and one for the generic manufacturer Gen BioPro. But the provider is being asked to make a specific recommendation, a specific a certification of the ability to assess the duration of the pregnancy accurately, ability to diagnose ectopic pregnancies, and either to have a provider have a plan for referral. And again, this is unusual, but these are things that should be embedded. The reality, and I'll come back to the ectopic pregnancy issue, is that based on the clinical research, that can be addressed after the fact by determining if the pregnancy is continuing, for example, with a home pregnancy test after the use of the medications. I wanted to make a recommendation here. This is something that this is coming, this is a personal recommendation from experience and advising providers in areas where, where standards are still in tension or emerging. I'm always an advocate for providers developing a practice protocol and essentially explaining the clinical research upon which they're relying, explaining their decisions and how they're basing the safety, efficacy of what they're doing, showing that they reviewed the literature, and assessing the risk issues. What needs to be done, and essentially creating their own sort of step by step for how they're going to treat patients, and including a bibliography. I'm not trying to create additional work for providers, but what I want to suggest is that if there is ever a review, whether it's in the context of a state, of a licensing agency or a regulatory body, whether it's in a lawsuit, it shows this is one way that providers can really show that they've put attention and thought into clinical safety issues, and it's a sort of step that has been effective in our experience at really getting providers to think carefully about compliance issues, which has to be a priority in a higher risk environment. Obviously, I covered a lot of this on the previous webinar, but some of the fundamental questions you have to always ask are you licensed to provide care in the state? You have to ask the question, what organization are you providing? Are you practicing through, complying with corporate practice of medicine issues, practicing in the majority of states that require through a professional entity that's qualified to do business in that state, asking the question about where you're insured and indemnified for practice, and then there are these abortion exceptionalist questions of handling out-of-state patients. Our view is that patients have a fundamental right to travel, and it is permissible to travel to treat a patient if the patient is in a jurisdiction or is if the patient verifies that they're in a jurisdiction where it's permissive, right? And this position, I'm not even going to comment on this position of whether the patient needs to complete the misoprostol. Clearly, there is risk in a state like Texas to the patient taking the miso in the state. And then you have to decide what information you're going to give your patient to. You can help patients, where you direct patients, and how you manage patient privacy. Some of the critical questions in terms of documenting the patient encounter, and I do have some comments on one of my next slides about what to consider not documenting, which is an unusual issue. Again, an abortion exceptionalist issue in the current climate. But ordinarily, key things to document are the compliance with any requirement to verify patient identity, addressing patient privacy concerns. We are getting a lot of feedback from providers that this is a significant issue. Patients are worried about their privacy. We're going to be talking more about that, and I have some other thoughts about that on another slide. But those issues. That I would advise providers who are prescribing medication abortion to really just have a very carefully set of documentation compliance for the REMS, the FDA REMS issues. That includes signing with the patient agreement, keeping a copy in the file, giving a copy a patient, providing the copy with the patient of the FDA Mifepristone medication guide. By the way, we are recommending providers that informed consent also be provided for misoprostol. It's not legally required. The decision, when I say informed consent, we always are in favor of form that has the risks, benefits, and alternatives, but also a discussion that's charted, that those were discussed with the patient had the chance to ask questions. And even though that is not something the FDA is requiring, it is a way that providers can protect themselves from and to demonstrate that they've gone above and beyond in addressing patient issues. Follow-up instruction sheets. Those are actually, one of the things that the REMS focuses on, but also just a matter of good patient care. And then there are the history issues. These are much better covered in the clinical literature of issues that a provider should address in their notes. There's this whole question of appropriate prior exam of what that means in this context, and that is a term that's used in all 50 states as a prerequisite to providing care. But in this context, it is really just a question of ensuring that the patient subjectively understands and is and is providing answers that can be relied upon. And so, the decision about whether there needs to be some interaction, whether there needs to be a discussion with the patient, is certainly something that's optimal, if possible, simply to protect the provider from a claim that they didn't sufficiently examine the patient. Examine here does not need to mean, certainly doesn't mean an in-person exam, but we still see that term appearing and coming up as an issue. And I'm going to cover these a little bit more on the next slides. I'll come back to that point also, but wanted to just give some other thoughts. Okay, so documentation is a tricky issue because ordinarily the medical record protects the clinician in most contexts from a licensing board enforcement issue, from professional liability cases. It demonstrates the thoroughness and the fundamental rule that you always hear in this context is if you didn't document it, it didn't happen. That's the kind of attitude that we see from state licensing boards and in malpractice cases. So that's the ordinary rule. And now we have this bizarre situation where it may be creating a risk for the provider or patient. And we've seen a lot of questions about what information will be accessible, and I will provide some thoughts on that. So I think it's very important. I would say my first recommendation here is that providers need to adhere to the guidelines for adequate record keeping, because that is an essential element of professional conduct. And failure to keep adequate records is the number one most common violation that state medical boards will actually use to discipline physicians. So there must be an adequate record of who was treated, and what treatment was done, and what the interaction related to that treatment was. I do think that there's a moment in time where it is appropriate to question what risks may be taken by virtue of our integrated electronic environment. And I don't mean to pick on these companies, but I will just use a couple examples where companies like DoseSpot, which integrates with e-prescribing software, and SureScripts, an e-prescribing software company, and Epic, the large medical records company, and not only these companies, but their records allow for some interactive use where it could be there could be a case in which information in those databases is not strictly private to the patient and the provider who are having the encounter. And so it may be appropriate until these issues are addressed to consider maintaining strictly paper records. The irony, by the way, is that many states, California included, have moved to mandatory e-prescribing systems. But e-prescribing may, again, ironically, be a risk issue here. And so that's an issue we're going to come back to and be focusing on in the future. But in this moment, we have given advice to that it may be safer and it may reassure patients to know that there are only paper records and to know that providers are going to steadfastly oppose subpoenas. And I will share with you, I have been in numerous situations not related to a medication abortion where states have sought particular information to subpoena medical records from patients without the patient's consent. And we have consistently advised telemedicine clients, and our telemedicine clients have consistently opposed those subpoenas. And so I just don't think that is, I think patients need to know that providers are not going to kowtow to unreasonable requests. And we're going to get into a whole area of new laws that are emerging in abortion permissive states where they are simply not going to recognize the validity of these requests. This doesn't help providers who are subject to laws, who are practicing in hostile states. But I make this comment for people who are practicing in abortion permissive jurisdictions and where either providers or their patients may be afraid of what risks there are. And so we're in a bizarre moment, that is for sure. Just a couple of words. It's interesting because there is really a gap, and I'm not a clinician, obviously, and I'm not going to get into the clinical issues, but I've included on this slide sort of the key points of what a provider is required to have a patient agree to, and in terms of the in terms of before doing medication abortion, this is what the REMS requires. But again, this is a very, in my view, the statement is a very aggressive statement, which is why providers may want to provide this and also something that is a little bit less scary and a little more on point with the latest research and what to do. I think there's a lot of work to be done here on how providers can communicate with patients safely. But I put this up simply to say that some of the issues here are addressable. And I've mentioned ectopic pregnancy as one where in early use of medication abortion, the simplest way to a provider can address this issue is to simply, ensure the patient understands that after the use of Miffy and Miso, they're going to need to do a home pregnancy test at a later interval, a couple weeks later, to ensure that the pregnancy is over. But the FDA REMS has very specific information. There's something I'm just saying providers may want to say something additional or slightly differently in addition to the legal requirement to provide this document. Okay. I don't know what I just did. People see my screen. Sorry, I'm going to reshare my slides because something happened where they froze. Bear with me for 1 second. This has been okay. So then just to continue, some of the key elements, just to recap, REMS compliance. These are the key elements of REMS compliance. There's also this medication guide that the FDA is requiring. And as well, by the way, just an additional note here, besides saving things in the chart, a provider who is actually dispensing is required to record the Miffy package serial number in the chart. And so anyway, so the provider should just be mindful of those requirements. So just to recap here, the key issues that a provider, going back to that initial framework that offered at the beginning of the webinar, the question of identity validation is really, or authentication, is a jurisdiction by jurisdiction question. It certainly is trending, not in a majority of states yet, but over the last several years, to comply with identity validation requirements. Providers should definitely be considering where to include disclaimers, disclosures, and education, and not limited to the FDA REMS requirements, which again only address mifepristone and not misoprostol. The main things in terms of the record, what needs to be in the record, the key thing is to document medical eligibility to ensure that the history of the patient includes any contraindications and exclusion criteria. And just to get back to this point about the exam, I don't think I hit it squarely. The exam, because if you are treating in a telemedical context, you are not using external diagnostics. Your exam consists of the physician review of the data that the patient input and any further interaction with the patient, right? That's really what it comes down to. Informed consent is not merely the forms, but also the charting of the discussion of risks, benefits, and alternatives. It's important, and also just under informed consent, it should be clear that the patient was informed about and wants to abort the pregnancy. In terms of things that a provider might consider not putting in the record, there's no requirement to chart why a patient wants the abortion. There's no requirement, and it may be risky for a patient if a provider charts what the patient may have done previously to induce an abortion before coming to the provider. There's no requirement to chart who the father is. I point these out simply to say that this is a strange example of where more maybe, I've had doctors say to me in the past, I have to be Hemingway with my notes. In this area, not so much, right? Doctors should ensure minimum adequacy in the notes. They should ensure privacy and data security are taking on a new level of importance here. And in terms of prescribing, they should document the treatment provided, instructions for use. By the way, the misoprostol use is inherently an off-label use, which ties into the recommendation to use an informed consent. Continuity of care instructions and emergency instructions. If you are a telemedical provider, typically you are not providing, you're answering questions if the patient has something that needs follow-up, but you're going to need to direct the patient to go elsewhere. And so this is an issue that does require attention. We're happy to speak after this webinar with anybody who's interested in thinking about what that should look like, and to providing specific instructions on how to handle emergency care. And finally, either writing a prescription to a pharmacy or dispensing in the places where that is permissible. So I just want to offer some final thoughts, and then I'm going to turn to the questions and answers. We are living through a time when there is a whipsaw pace of change in state after state, and it's very tricky. It's very hard to keep giving for lawyers to give advice where there's constantly new laws, new legal decisions. And we are going to continue to do our best, as will other lawyers. And I apologize for anything in this that is that becomes out of date soon or that may be confusing. There are places where there's room for different views. I mentioned Alaska and Montana; those are states where it actually is complicated to figure out what the law is. I want to suggest, and part of our intention in offering this webinar was that that the best approach to those people who are trying to provide information and access to medication abortion via telemedicine is an allied approach, where telemedicine and telehealth regulatory perspectives are hopefully a valuable piece of a multi-layered approach. And I want to encourage people to think about abortion exceptionalism and where it needs to be called attention to and where it needs to be addressed. And I would argue that aligning some of the clinical standards and the research that's come out with and working with manufacturers to update the REMS should be a priority, because that to me is clearly, once the FDA makes pronouncements, those are going to inform standard of care, and there is some tension and some ways in which they are supporting barriers to access here. As I mentioned, we're going to be having 2 future programs for people who are interested in getting into the liability risks. I look forward to including my partner, Mark Hardiman, a former federal prosecutor, who's going to weigh in on that topic. And we're going to be. I'm looking also at working with collaborators on privacy concerns. I want to go to the questions and answer. I apologize. I was doing this webinar by myself, so I didn't have I am seeing the chat comments that would have been good if I had seen them earlier about my microphone. I apologize for that. Let me go to the Q&A and try to do as much as I can here, and then I will and I get some questions. So Michigan currently requires in-person. Michigan requires in-person and ultrasound, right? So that is, again, I'll circulate for anybody who would like. We'll circulate the slides, and I think that a lot of these state ultrasound requirements really, if you're looking at the clinical studies, it's not clear that any state that intends to create access should consider whether it is unnecessarily impeding on that basis. Thank you, by the way, for the comment that West Virginia's ban was blocked yesterday in court. Perfect example. My slides are already out of date. Okay, sorry. So I skipped a question there. Do we have can you give, if you use paper records, would that be an issue in compliance with the Cures Act, or would it be okay as an information blocking exception? I do think it's a good question, right? There are a lot of cases, electronic records, meaningful use, subsidies and requirements, e-prescribing requirements at the state level, where paper records may present some risk. My belief is that through dialogue with state medical boards and in abortion permissive states, until the privacy issues are addressed, I think there is room for providers reasonably to treat this issue as exceptional, and I think we need to seek further protection for both providers and patients. But I am giving advice at this time that it is more important to protect privacy than to comply with some of these technical documentation requirements. The question was asked, most likely and worst possible scenario, if a provider gives medication abortion via telemedicine and the patient is from a hostile state but provider's in a protected state. So if the provider is not licensed, the question is whether there would be pursuit of unlicensed practice of medicine. It's a very rare scenario. We see a lot of examples where telemedicine providers are treating patients across state lines, even when they shouldn't, and we see very little enforcement on activity. As I mentioned earlier, I do not personally believe that state medical boards are going to be the ones pursuing this. I think the worst possible scenario would be for advocacy organizations like the Texas Freedom Caucus to make good on their threats and to initiate litigation. But so I do think that providers need to be careful. And I think, by the way, I want to make a comment here that I didn't address on this, which is one thing we have seen that has been a challenge in telemedicine has been people who are not in good faith seeking the care they need, right? An out-of-state patient, presumably a legitimate patient, is going to be extremely concerned about privacy. And if a provider, for example, in good faith prescribed a medication that turned out to be to a patient in a different state, it seems very unlikely that that's ever going to surface because of the provider's going to treat it privately and the patient's going to treat it privately. What's worrisome is the undercover activists, or in the past we've had undercover medical board investigators pursuing issues like this, and I do worry that those are going to be ways that providers can get caught up, which creates some question about how providers should validate that they're working with a real patient and look for signs of suspicious people who are not legitimate patients. The question was asked, we have concerns about instructions to bring the MIFI guide to follow up emergency care in a hostile state. I absolutely think it's a great point. This is a bizarre case where the FDA requirement, the FDA REMS requirement to bring the instruction is inconsistent with just practical risk advice. And I think a patient would have to be crazy to bring a medication guide to a hostile state without knowing how the facility or the doctor is going to handle it. And frankly, I would advise patients to shred documents they have, and to be extremely careful about sharing any information in the current environment. And I think the dust will hopefully settle in the coming months. But we're seeing, the example of the Texas letter is one where this is just such an uncertain environment. That I would not advise patients to. Patients certainly don't have to worry about the FDA. And as long as providers give the advice, they can certainly couch it. The FDA is not policing providers. Very important to note, the FDA does not, once the FDA acknowledges that something is in the sphere of the practice of medicine, it defers to state law, and the FDA doesn't pursue enforcement directly. And so, okay, then the question was asked, any information on providers who are physically in more hostile state, but licensed and safe ones? Our advice, this issue came up on our last webinar, and our advice is to maintain extreme privacy. We are clearly seeing that activists, potential plaintiffs in hostile states are interested in maximizing the level of intimidation to scare people out of providing care. So even though the provider in a telemedical regulatory framework is providing care in the state where the patient is located, and if that provider is physically in a more hostile state, I would definitely want to exercise caution, because you are subject to the jurisdiction and to if it came to light. So I do think that is a concern. We're over time, so I'm going to the rest of the questions we will answer. I will provide specific written answers to these questions in the next by the end of the day today, and we will just anonymize the questions came from and share those upon request. Anybody who is interested in that, please email info@hnelsonhardiman.com, and we will be glad to provide that in this webinar. I hope that this has been helpful. I apologize for the technical glitches, and look forward to answering more questions, and hope to see you on our future programs. Thank you.